Hello, my name is Dr. Gabrielle Watson and I'm a Fellow in Law at Lincoln College, Oxford. I work on topics at the intersection of criminal law, criminal justice, and legal philosophy. I would like to begin by expressing my gratitude to the Assize Organising Committee for the opportunity to share my ideas with you today, and to His Honour Judge Farrell for taking time away from his duties to comment on the paper. As an early career academic, this is a tremendous honour. My topic is the guilty plea from an ethical perspective. As is custom at these seminars, this is a work in progress and will eventually appear as a chapter in an edited volume by sentencing scholar Julian Roberts and philosopher Jesper Ryberg. On screen you will see a short PowerPoint presentation which I hope will give a sense of the structure and flow of the talk and will guide me in my remarks. Let me begin with the legal background. A plea of guilty is a formal reply to a criminal charge and must be entered by the defendant personally. It is essential that the plea be unequivocal. If the court is satisfied with the plea, the prosecution is released from the obligation to bring evidence and prove the defendant's legal guilt beyond reasonable doubt. There is no need to assemble a jury, and the defendant stands convicted simply by virtue of the word guilty that he has uttered. The effect is that we have a negotiated form of justice whereby the defendant essentially self-criminalizes or self-convicts. Once a plea of guilty has been accepted, the court may then commence the procedure leading up to the passing of sentence. The fact that a plea of guilty has been taken into account must be made explicit in the sentencing remarks. The high rate of guilty pleas means that the contested trial, in theory the adversarial system's chosen mechanism for determining the question of legal guilt, plays no part in the vast majority of criminal cases in England and Wales. It is a well-established principle that a plea of guilty attracts a reduction in sentence, with the scale of the reduction being greater the earlier the plea is intimated. The principle was first established in English common law and is now placed on a statutory footing in the Sentencing Act 2020. In 2017, the Sentencing Council of England and Wales published a definitive guideline on reduction in sentence for a guilty plea. The purpose of this guideline is to encourage defendants to plead guilty as swiftly as possible, with the prospect of a substantial discount of 1/3 if the plea is entered at the first stage of legal proceedings. And there's a sliding scale of reduction thereafter. The reduction should normally be decreased further, even to 0, if the guilty plea is entered during the course of the trial. By requiring a plea at the first hearing to obtain full credit, the early guilty plea removes judicial discretion concerning any reduction. The 2019 case of Hodinot, I think, is worthy of our attention. In that case, the court considered the submission that the first defendant in a multi-handed drugs case to break ranks and plead guilty, thereby encouraging others to do the same, ought to receive additional credit for the guilty plea. The court observed that the maximum credit for a guilty plea, pursuant to the Sentencing Council's definitive guideline, was 1/3. However, an additional reduction in sentence might be permitted by way of mitigation. The court maintained that this would be a fact-specific decision, and so no fixed rule has emerged from that case. Why think ethically about the guilty plea? The academic literature on the guilty plea has escaped harsh criticism in England and Wales when contrasted with the United States plea bargaining system. It has largely focused on 3 key themes. First, its statutory basis and the role of the sentencing guidelines. Second, its role in securing a plea-based sentence discount. And third, its prevalence, over 70% of defendants resolve their case by entering a plea of guilty. No doubt this scholarship is rich and extensive, but it is also narrowly instrumental and pragmatic. The guilty plea calls out for analysis in ethical terms, and it is striking that legal scholars have so far merely hinted at the relevance of this kind of work. A note on method. I propose to introduce a concept from ethics, self-respect, into sentencing law and scholarship in an attempt to shed new light on the practice of pleading guilty. There are at least two ways of going about this task. We might begin with the ethical concept and then apply it in a top-down way to the guilty plea. Alternatively, we might begin with a pre-existing aspect of the legal process, in our case the guilty plea, and seek to unearth its ethical presuppositions while holding true to its conceptual features. In this talk, I propose to adopt the latter approach. The essence of my argument is as follows. A certain ambivalence to the act of pleading guilty. We might even say that it is a contradiction in terms. It has the capacity to generate quite conflicting sentiments, where we might at once morally approve of and morally object to its existence. On the one hand, the guilty plea is a gesture of contrition, a form of atonement, and a public acceptance of legal responsibility. It is morally praiseworthy. On the other hand, it is a tactical decision made for personal gain in the form of a plea-based sentence discount, when the defendant might well be factually innocent. These conflicting interpretations mean that, depending on context, the guilty plea can both promote and erode a defendant's self-respect. The remainder of this talk then will be in three parts. First, I will introduce the ethical concept of self-respect. Second, and against this conceptual background, I'll draw attention to what I perceive to be some ethical complexities where the guilty plea is concerned. Finally, I will acknowledge the merits and limits of my ethical analysis. I suspect that some audience members may consider this a rather abstract intellectual exercise, an attempt at achieving a level of conceptual precision of interest only to legal academics. However, I hope to convince you that when we reconcile sentencing law and scholarship with concepts from applied ethics, it can be a concrete exercise too, with implications for the defendant in particular and the sentencing process in general. Ethics, like law, is by its very nature a regulatory instrument. As a system of moral concepts, it recommends what ought to be done or avoided. It too can be grounded and pragmatic. I will now set out the concept for discussion, self-respect, and explain why I think it is well suited to an analysis of the guilty plea. In the philosophical literature, self-respect is defined as a person's regard for his intrinsic worth or value. It is considered morally necessary for a meaningful life. Self-respect is deeply related to an individual's identity, affecting his thoughts, desires, values, emotions, commitments, dispositions, and actions. It suggests an engaged understanding of one's worth, as well as a desire and disposition to protect and preserve it. Saying that an individual has no self-respect or acts in a way that no self-respecting person would act amounts to very strong moral criticisms. But work on self-respect is not restricted to individuals. It is regularly suggested in the philosophical literature that legal institutions and practices are to be judged just or unjust, at least in part, by how they impact an individual's self-respect. So, self-respect operates at both the individual and the institutional level, and often overlap. John Rawls' work in A Theory of Justice is instructive here. For Rawls, self-respect is an entitlement that institutions are required by justice to support and maintain. He argues that individuals' access to self-respect is to a large degree dependent on how the basic institutions of society operate. This includes the messages about the relative worth of citizens that are conveyed in the structure and functioning of these institutions, including legal ones. Rawls argues that justice requires that social institutions and policies be designed to support and not undermine self-respect. I consider self-respect to be a valuable ethical tool for making sense of the guilty plea because it's able to capture the plea's ambiguity in practice. Like self-respect, the guilty plea too operates at the individual and the institutional level. When considered in ideal terms, the practice of pleading guilty can preserve a defendant's self-respect, but too often, the guilty plea is handled in such a way as to erode it. I will now develop this argument with reference to two concrete examples. In developing an ethical critique of the guilty plea, we could go in a number of directions. We might consider the circumstances in which a reduction should be available and at what stage, the level of reduction that should be offered, the impact of a guilty plea at different stages, its implication for victims and witnesses, the motivation behind entering a guilty plea, and the circumstances that might incentivize or discourage an early plea. But I am limited on time and I must inevitably make a selection. I will consider two features of the guilty plea as set out on the PowerPoint, both of which I think have important implications for a defendant's self-respect. According to the Sentencing Council, nothing in the guidelines should be used to put pressure on a defendant to plead guilty. Yet, it seems to me that there is a very fine line between incentivization and inducement where the guilty plea is concerned, and the practice of advertising plea-based sentence discounts could easily attract criticism from ethicists. While incentivization has a positive connotation, inducement invites negative connotations. It might persuade an individual to do something that is ethically objectionable, or, in the case of pleading guilty, to act against his own best interests. In 2014, McConville and Marsh coined the term state-induced guilty plea. Too often, the guilty plea is a tactical decision rather than a mere admission of guilt. The current system seems to assume that plea decisions are truly autonomous and consensual, despite increasing empirical evidence that this is not the case. Given the sizable sentence discount available, the factually innocent might be induced into pleading guilty in the face of weighty evidence against them. The practice is extremely common in North America, where plea bargaining can result in some truly striking discrepancies between the sentences for guilty pleas and sentences after trial. Even if the trial penalty is smaller in England and Wales, the same ethical concern exists. The risk is that such practices become normalized and pose a serious threat to a defendant's self-respect. It seems to me that the notion that defendants have complete freedom of choice over a guilty plea is somewhat of a myth. It seems difficult to accept that strategic pleading does not form part of some practitioners' everyday working practices, and that this may lead to manipulation of a client's plea. That behaviour is clearly unethical if matters such as self-interest or convenience compromise the best interests of the defendant. In the 1970 case of Turner, the court was reluctant to acknowledge that counsel may exert undue pressure on a defendant, and that his advice on plea could itself overwhelm the defendant's free choice. The Court of Appeal maintained that this was an extravagant proposition, which would only be made out in an extreme case. Yet since Turner, there have been several noteworthy appeals from defendants claiming to have been put under pressure to plead guilty. Convictions that occur as the result of plea and not trial have been described in the academic literature as convictions by consent. Yet, I'm inclined to resist that interpretation. Legal rules and procedures, together with legal advice, have the potential, at least, to distract attention from systemic coercion and to fix responsibility for the plea on the defendant alone. Our ethical interpretation of such convictions is dependent on the reasons why the defendant decided to plead guilty. As far as self-respect is concerned, it is worth noting that a defendant who pleads guilty does not truly have his voice heard. This is suggestive of a transactional, even disinterested form of adjudication. The defendant is required to utter a single word, guilty. Even the word itself has a certain indeterminacy. In fact, guilty, I think, is a striking example of a word that has a core of settled meaning, as well as non-focal meaning over which there may be disagreement. Usually it's deemed by the court to mean I acknowledge the prosecution case is true. If there is a basis of plea, then the word might be deemed to mean I acknowledge the basis of plea is true. This is despite the fact that the plea will often be a deliberate construction, a strategic decision, or a compromise between conflicting accounts honed through negotiation. As we know, a guilty plea produces greater benefits the earlier the plea is indicated. That is not a straightforward decision for any defendant to make, let alone a vulnerable one, where full credit may be withheld if there is no definite indication of a guilty plea at the first hearing. It seems to me then that the Sentencing Council's guideline risks having an adverse impact on vulnerable defendants who are already subject to external pressures and in need of protection from the justice system. It is well known that the demographics of the typical defendant overlap in many ways with the demographics of the most vulnerable groups in society. Defendants tend to share a common profile. Nearly 2/3 are hard drug users, more than 1/3 were in care as children, half have no qualifications at all. Greater proportions of the vulnerable may be induced to decide matters against their best interests. That may be regarded as a positive outcome by the incentivizer because of the benefits that accrue to the legal system, even if they do not accrue to the recipient. The issue is particularly acute at the pre-trial stage when time is limited. The period between arrest, charge, and attendance at magistrates' court may be a matter of hours. This is important in considering the impact of the early guilty plea regime. Since the first hearing is the only point at which the maximum discount is available, this presents a dilemma for the defence. If they lack information about the case against them, how do they proceed? There is clear evidence that pre-trial disclosure by the CPS is often inadequate. Yet the vulnerable defendant is still expected to enter a plea at the first stage of proceedings. He will often require expert legal advice before he can sensibly decide on his plea, for example, as to whether the case should properly be contested on the basis of, for example, absence of intent, self-defense, diminished responsibility. The failure to plead guilty at this stage is tantamount to an automatic increase in sentence in the event of a guilty verdict. The suggestion that this does not create pressure on vulnerable defendants is unconvincing. No one should be expected to plead guilty without knowledge of the full case against him. All of this is simply to illustrate that placing the current emphasis on the difference between a reward and an incentive may not only miss the point, that this approach is inherently pressurizing, even coercive, to vulnerable individuals, and from an ethical perspective, much less straightforward than the Sentencing Council presupposes. One suggestion is that, in the interests of the vulnerable defendant's self-respect, an exception ought to be made to allow him more time to obtain legal advice and a reasonable opportunity to reflect on it before deciding on his plea. Careful decision-making requires defendants to be fully educated on the matter. They must be able to take a sense of ownership of the decision, using their own discretion and good judgment. The current emphasis on speed, the entering of a plea as swiftly as possible, implies a significant disregard for the vulnerable defendant and erodes his self-respect. It is the defendant, after all, who will suffer the consequences of conviction. I will now say a few words about the merits and limits of my ethical analysis. I have proposed two principal ways in which the guilty plea, as it currently operates, can erode a defendant's self-respect: the issues of incentivization and inducement, and the issue of vulnerable defendants. At no point do I assume that there is a universally right ethical point of view, but there are strong and weak versions of my analysis. The strong version is that we move to end the practice of plea-based sentence discounts altogether. It ought to follow from the presumption of innocence that a defendant can legitimately invite the prosecution to prove his guilt without being penalised for doing so. Yet this is precisely the point of sentence discounting. A defendant who contests the case against him inevitably receives a higher sentence than a defendant whose circumstances are identical, save the fact he entered a plea of guilty. The weak version of my analysis is to expose the guilty plea as ethically suspect, a contradiction in terms that is worthy of sustained ethical reflection. The concept of self-respect paints, I think, a rather inconclusive picture of its ethical plausibility. One view is that the state places a moral burden on the innocent defendant by incentivizing him to self-criminalize or self-convict, where the hidden cost is a loss of self-respect and an exclusive concern with instrumental outcomes. Yet if we consider once more the Rawlsian view of self-respect in the context of criminal justice, then ethical principles such as justice and fairness should always be deemed superior to utilitarian principles insofar as they better affirm self-respect for defendants. The current guilty plea regime in England and Wales calls the Rawlsian view of self-respect into question. The alternative view is that the guilty plea has redeeming features worth preserving. Without a trial, crime victims and witnesses are spared the experience of attending court to testify. For many victims and others with a personal stake in the offence, testifying in a public forum can be emotionally distressing and is ideally avoided. Victims often benefit from knowing that the offender has accepted responsibility by admitting guilt and might even view the plea as indicative of remorse, even though the matter is technically dealt with separately by the court. For the offender, the possibility of a reduced sentence might encourage him to take responsibility for his actions and may constitute an important step towards a law-abiding life. Finally, there is the utilitarian argument that the guilty plea is in the public interest, since it drives more efficient and expeditious processing of criminal cases and saves public money on investigations and trials. In conclusion, then, my aim has been fairly modest: to open up a new kind of discussion and to expose the act of pleading guilty as a fundamental ethical moment in the criminal process. I suggest that we need to consider with greater precision the ethical dimensions of pleading guilty. One of the most striking and underappreciated features of sentencing law and scholarship is that key ethical concepts, such as self-respect, underpin almost all topical issues. Greater sensitivity to these concepts is crucial if we are to rationalize, defend, and recommend the continued use of the guilty plea and sentencing discounts. Self-respect serves as an effective tool for moderating the ethics of the sentencing process and might even be viewed as a critical and regulative ideal. A revised approach to the guilty plea for the 2020s would preserve the redeeming features of the guilty plea, while ensuring that it is kept in its proper place by balancing it against other forms of mitigation at sentencing, including remorse. And once the foundations for an ethical approach have been laid, it's important that these ideas are not restricted to the legal academy. Rather, they must begin to infiltrate sentencing law in practice, in pursuit of a system that is more receptive to ethical values such as self-respect. Thank you for your time, and I look forward to the seminar on the 14th of May.